Good afternoon, good evening, everyone. My name is Myriam Henin. I am a professor in law and religion and comparative law at UCL. And it gives me great pleasure to welcome Raphael Cohen-Almagor, who is a professor in politics and the founder as well as the director of the Middle East Study Group at the University of Hull. Raphael will be presenting his new book entitled Just Reasonable Multiculturalism, Liberalism, Culture and Coercion, recently published with Cambridge University Press. To discuss Raphael's book, we have a prestigious lineup of speakers with us. Lord Neuberger, former president, as many of you will know, of the UK Supreme Court. Justice Professor Elyakim Rubinstein, formerly Vice President of the Supreme Court of Israel and formerly Attorney General of Israel, and Professor Avrom Sherr, former Director of the Institute of Advanced Legal Studies, who now leads the operation of the independent peer review on legal aid in England and Wales. Very modestly, our speakers have asked me not to introduce them anymore fully. I will oblige, mainly because their career achievements would be too extensive for me to present concisely here. Our main focus, as it should be, will be therefore on Raphael's new book, the latest edition to an impressive and long list of publications. Raphael's new book offers a very timely reflection, both theoretical and contextual, on recent delicate tensions between liberalism, multiculturalism, and religion. There is another reason for me, a more personal reason for me, to be especially delighted to be chairing tonight, beyond the importance and timeliness of the chosen topic. If I may divulge a little story behind the book, I will say that Raphael wrote part of the book while he was a visiting professor with us at UCL Laws. And I remember fondly the discussions we had at the time as you were writing the book, Raphael. It is therefore fitting that UCL Laws should be hosting Raphael's book launch. I am very grateful to the colleagues at UCL Laws who ensured that it could happen. Let me single out Lisa Penfold and Kat Ballaghan from the events team at UCL Laws, Professor Iris Chu, Director of the Centre for Ethics and Law, and in particular, Dr. Alan Brenner, Deputy Director of the Centre for Ethics and Law, without whom we wouldn't be here today. My final thanks obviously go to the author, Raphael, for writing the book, to the speakers, and for you all in the audience for commenting upon the book. As is customary, I will first give the floor to Raphael for him to introduce his book, and then ask each of our eminent speakers to speak to the book for about 10 minutes, 15 minutes each maximum. I will then open up to a Q&A session. If you would like from the audience to ask a question, and you haven't already submitted one ahead of the event, please use the Q&A section, and I will forward your section time constraints depending at the end. Raphael, the floor is yours.
So let me first say thank you. Thank you to UCL and to Alan Brenner, who initiated this event. It was his idea. And to Myriam and the Dean, and of course to Lord Neuberger and to Justice Rubinstein and to Professor Sherr and all the team at UCL for organizing this. I deeply appreciate. The book was written, the majority of it was written while I was visiting UCL in 2019. However, it is a product of many years of thinking and research. Actually, my journey in the field of multiculturalism started in 1993 when I was a fellow at the Valley Jerusalem Institute, and I belonged to a fascinating group of scholars who study the influence of Europe on the Middle East and the influence of the Middle East on Europe. And this was my entry to the field of multiculturalism. So for many, many years, I've been working on the field, and I'm well versed of the argumentation against multiculturalism. So traditionally, there were two attacks against multiculturalism. One that is bad for democracy, for the simple reason that in liberal democracy, everything stems from the individual, everything returns to the individual. The individual is the center of attention, whereas multiculturalism put at the center group rights. And then there's a question, what happens when group rights clash with individual rights? So some claim it's bad for democracy because it may harm individuals. The second traditional attack on multiculturalism came from feminists saying it's bad for women. Every time that there's a group holding up cultural reasoning above individual rights, the victims are women. Just think of yourself, even from infancy, infanticide, and female circumcision and female genital mutilation, and sati, murder for family honor, forced marriages. All these practices stemming from whims of men are hurting women. And therefore, many feminists object to multiculturalism. While I was aware of these attacks, and I was writing articles here and there about multiculturalism, during the years I was preoccupied with other issues that interested me and wrote about other subjects. But what prompted me to write this book and to engage was a statement by Prime Minister David Cameron, who said no less that multiculturalism is bad for England, that is hurting England, doesn't contribute to England, and it leads to radicalization and even to terrorism. This really upfront attack on multiculturalism brought me to think, okay, now I think it's for me the time to sit down and write a book. So the book that was published last July is a product of about 10 years of working on the book since David Cameron made this statement. The thesis that I bring forward in the book is that multiculturalism and liberal democracy can be reconcilable, and it is possible to secure what I call the Aristotelian golden mean between liberalism and multiculturalism, but this is provided that the mechanism for reconciliation between liberalism and multiculturalism are just and reasonable. The question that I'm tackling in the book are the following. Are group rights related to individual rights? Because that's the first attack that's in undermine democracy and liberal democracy and the autonomy of the individual. What should we do if group rights come into conflict with individual rights, especially when it comes to vulnerable populations like women and children? And when should liberal democracy interfere in the illiberal practices within its subcultures, within illiberal cultures, within liberal democracy? And that's the most complicated questions to try to define the boundaries of interference of liberalism within illiberal cultures. Let me go on with an overview of the book. So the book is split to three parts. The first part is the theoretical part. I'm a political scientist. In political science, usually there's a theory that underpins the reasoning. So I developed a theory of just, reasonable multiculturalism. That some of it is mine and some of them is borrowed, and together they relate or comprise a just, reasonable multiculturalism. I'm of the opinion that of the values, of all the values that we can think of, the most important value is justice. If we'll be able to secure justice, then ipso facto, all other values that we appreciate, like liberty and equality and tolerance and truth and constitutions and others, they will be satisfied. The question, of course, begs, how do you define justice? And for many hundreds of years, there were discussions about what is just and so on. And this query was addressed, I think, fully and in the most comprehensive way by John Rawls, who engaged with the issue of what is justice for 20 years, from the 1950s until 1971, when he published A Theory of Justice. And this book serves as an inspiration to many thousands of scholars around the globe, including myself. So first, I go approach Rawls, and with him, with his help, I'm engaged with the question of what is justice. The second thing that I need to explain is what is liberalism and what is democracy. And this is what I do in the first chapter. And I should say that the book is related, is relevant only to democracies. I'm not dealing with theocratic or authoritarian or dictatorship, not because I don't think that this theory would not be applicable to them, but simply because I'm practical. I can speak endlessly about the rights of women, but to what extent this is going to ring through in places like Iran or Saudi Arabia. So I could restrict myself to democracies. The second part of this theory is to do with the concept of reasonableness and, of course, with multiculturalism. According to Rawls and others, being reasonable is something that is going to supplement, is part of being just. And multiculturalism, of course, needs to be explained because the book is about the pluralism of many, many cultures within democracy. The third component of the theory has to do with compromise and delivery of democracy. I believe that a lot of the tensions, a lot of the schisms that appear within society can be reconciled, can find a way through mechanism of compromise. And this is provided that we speak up, we exchange ideas, we deliberate, and we find a way out. And the fourth and last component of the theory has to do with the concept of coercion. It also appears in the subtitle of the book. Why coercion? Because if the liberal democracy decides to interfere in illiberal practices inside democracy, it has to resort to coercion. Now, we all have sort of a knee-jerk feeling about coercion. We don't like coercion. But when you come to think about this, our life is saturated with coercion. We have to pay taxes whether we like it or not. We send our kids to schools whether we and they like it or not, at least at the age of 16 or 18 in some other countries. We serve on juries whether we like it or not. Some of us go to the army when there is draft, whether we like it or not. And of course, we all have to obey laws, whether we like it or not. So coercion is part of our life. And sometimes we need to resort to it when there are applications, when there are practices that, in our opinion, as liberals, as democratic people, we think that are beyond the pale of tolerance. So that's the fourth component, the fourth prong of the theory of just, reasonable multiculturalism. The second part of the book has to do with applications. And what I've done, I divided application into two parts. Those that have to do with physical harm and those that have to do with non-physical harm. I think it's easier when you have physical harm at stake, because if I'm swinging my hand and I hurt your nose and you start to bleed, this is noticeable. We can see that. This is tangible. And whereas when there are issues when there's no physical harm, then I think the discussion is becoming more complicated. So let me start with physical harm. And here I'm looking at issues like murder for family honor, scarring, torture for tradition and honor, female circumcision, and male circumcision. The non-physical harm has to do with discrimination of women and apostates and denying education to children. The last part of the book has to do with two countries that are democracies but are not liberal. In both of them, we find coercion by the majorities against the minorities. In France, for some reason, they have this obsession with Muslim dress. In Israel, we'd find that there's always a tension between the majority, the Jewish majority in the country, and the Arab minority of the country. And then there's the conclusion, bibliography, and the index. So this is the overview. Let me say some words about the issues of harm that I spoke about. We can distinguish between self and other regarding harm, and it's easier for us to tolerate harm that people do to themselves. For instance, inflicting pain on ourselves, or even starving to death, or scarring. And this should be differentiated from inflicting damage on others. So this is an example, this is scarring, that in some cultures, they are a sign of entering into adulthood and a sign of beauty. And I'm of the opinion, expressed in the book, that scarring should be tolerated, provided that it's not too harmful, that it doesn't lead to death. I'm very much against sati. This is widow burning. My Indian scholars friends tell me that sati is no longer prevalent in India, has not been for the past 150 years or so. But for many generations, if a woman had to bury her husband, then the congregation would assemble and she will have to die. Not only die, but die in the most atrocious way that you can imagine, in the pier of fire. And I asked Indian friends of mine and scholars whether this is something that, according to the Indian tradition, not liberal tradition, but Indian tradition, whether it's something that should be accepted. And they said no. Women were put in all kind of pressure to do this for all kind of ulterior motives that were not really related to the welfare of women. I am also very much against murder for family honor, and I think that, as Justice Rubinstein, I think, said in one of the justice, honor has nothing to do with this kind of conduct. And of course, we should not mitigate penalties because someone would say, well, this is a private business, had to do with my tribe, my community. You, the state, should not interfere. We are going to settle our own differences as we see fit. Well, in democracy, this is simply unacceptable. I differentiate between female circumcision and female genital mutilation. I discovered in my research that in some communities, in some tribes, all that they do is a scar in the outer labia. I don't think that a scar on the outer labia is more harmful to the women or to the young girls than male circumcision. And if there are traditions, if there are cultures that endorse this, then we should accept this and we should not interfere. On balance, I put the harms of interference, and always when the state interferes into tribes and communities, they're going to be harm. And of course, to the harm to the third parties, to the women involved here, or to the girls involved here. And in the calculation of harm here, balancing one against the other, in my opinion, we should allow symbolic scars as signs of female circumcision. These should be differentiated from female genital mutilation, which is a form of torture. And I'm against any form of torture, notwithstanding what kind of torture it is. Female genital mutilation, usually they cut almost everything, the clitoris, the labia, the outer labia, and so on, and they leave only a small hole for the women to urinate. So every time that she urinates, she's in pain, not to mention any sexual intercourse. This is, for me, a form of torture, and this should not be allowed. The most difficult chapter for me to write was about male circumcision, because I was trying to find a way between the rights of the newborns and the right of male circumcision, right, R-I-T-E. Of course, male circumcision is extremely important in Judaism, is extremely important in the Muslim culture, and for some Christian denominations. And I was in pain to find a compromise, a way out that is going to satisfy the rabbinical authorities and going also to satisfy the newborns, the rights of the newborns. I said I'm against torture. It took me some months of consideration and consultation with rabbis of Reform and Conservative, Orthodox, with male circumcisers, with physicians, with authorities on this, and I think I found a way. If you want to find what's the way, what's the proposal, you need to read the book. Now we come to non-physical harm, and here I'm looking at all kinds of practices that are done in United States and Canada. It has to do with discrimination of women and apostates, especially when the women are made out of the tribe. And apostates, those who negate the religion of the tribe. They've been discriminated against. And I criticize the Supreme Court decisions of both the United States and Canada that, in my view, gave too much leniency for the tribes and not to the women and to apostates' concerns. And of course, here I'm grappling with the issues that is bad for democracy, and the second challenge that is bad for women. The second case is Hofer versus Hofer that had to do with the powers of the Hutterite Church over its members. So it discriminated against members who abandoned the tribes and wanted to leave. The third case has to do with Scorsese versus Yoder. That's a case of denying education to children. The Supreme Court of the United States sided with the Amish on this. I side with the lone dissenter on the court that said that this is an infringement, unacceptable infringement on the right of the children. So the last part of the book has to do with two country case studies. One is France, coercion by the majority. And I'm explaining why the French have these strong sentiments against the Muslim garb. And also show how ludicrous it is when it comes to the burkini, if you can guess what is the burkini and what is a diving suit. In Israel, it has to do with the fact that Israel is a Jewish state by definition, and 21% of the population is Arab. And we find there is coercion of the majority of the Arabs by the majority. In other parts of the book, I also discuss the issue of Jewish Orthodoxy coercion versus secular Judaism. And this, of course, here I'm grappling with the first and the second challenges, and also the issues of security. I'm promoting egalitarian policies. I'm speaking for representation of minorities, and I'm also speaking about adding and amending symbols of the State of Israel. Few words about the cover. Cambridge University Press allowed me the decision what to put on the cover, and I was toying with all kinds of options for some months. And then I decided on this one. Why this one? Well, first of all, I don't know to what extent any one of you have been in Jerusalem during that time. For me, it's one of the most moving pictures they can witness in your lifetime. Every time that I'm in Jerusalem and I'm watching the walls of the old city during dusk, I shiver, I tremble. But beyond the fact that it's beautiful, immensely beautiful scenery that you can see, Jerusalem, of course, is a holy city for the three Abrahamic religions. It's also a very multicultural city. It's a very old city and treasured city. And my book is all about bridges. It's all about creating bridges and trying to avoid or destroy or do away with walls. And if you are able to overcome the walls, you will be able to see the light. Lastly, I want to mention three people. I dedicate this book to Yehuda Elkanah, the late Yehuda Elkanah, to Biko Parek, and to Will Kimlicker. Yehuda Elkanah was the president of the Valley Jerusalem Institute when I finished my studies at Oxford University and returned to Israel. And Yehuda paved my way and welcomed me back to the Israeli society. He opened the red carpet, he embraced me, and he gave me carte blanche to study all the projects in the Valley Institute and to choose whatever I wanted to do. I've been a fellow at Valley for 8 years of my life. And of course, he introduced me to the field of multiculturalism. Secondly is my good friend Biko Parek, who studied with me many of the issues of the book, who read each and every chapter of this book and commented upon it, And of course, he served as a great inspiration for me in the study of multiculturalism. And the third is Will Kimlicka, who studied before me at Oxford. I read his doctorate. I was deeply impressed because in my time at Oxford, people like Ronald Dworkin or Bernard Williams or Jerry Cohen hardly ever spoke about culture. And I thought culture is far too important to be ignored. So for me, Will was a fresh of air to highlight the importance of culture and to highlight the fact that it is possible to put together liberalism and multiculturalism. Thank you very much.
Thank you very much, Raphael, for an enlightening presentation. I will now immediately turn to Lord Neuberger.
Thank you very much. Just as a fair balance must be struck between individual autonomy and the law of the state, so there must be a fair balance struck between the actions and beliefs mandated by a community within the state and the state's laws. I think the principle is hard to quarrel with, but the devil's in the detail, in particular in the word fair, a fair balance. The concept of fairness is not only subjective, but it's also, at least initially, instinctive. One of the first conceptual statements a child makes is likely to be, "It isn't fair." The notion of fairness is almost hardwired into our brains. It's fundamental to the rule of law and fundamental to a just and successful society. Fair elections, fair justice, fair selection systems, and generally the principle accepted of those in charge should treat the individuals in their charge fairly. And fairness in many cases involves achieving a fair balance, often between competing interests, sometimes between competing attractive choices, sometimes between unattractive options. And the fair balance is, of course, familiar to judges and lawmakers, and it's particularly come to the fore in this country since we incorporated the Human Rights Convention, in effect, into our law 21 years ago. Since then, judges have been doing for some time what judges in other jurisdictions have been doing for longer, balancing individual rights or human rights against the legitimate interests and concerns and wishes of society as expressed through the legislature and the executive of the state. In other words, considering whether legislation and administrative actions successfully achieve the requisite fair balance in cases where they curtail or impinge on individual rights, including, of course, the rights of groups. The exercise of assessing the fairness of a measure doesn't mean that we're moving into a world run by judges. There's a gray area. Just because I wouldn't have done something doesn't mean that it's unfair. People have different views of fairness, and the extent of the latitude which a judge should allow to the other arms of government will obviously depend on the circumstances. Fairness is not only flexible when it comes to being considered in the facts of a particular case in a particular time. Looking across time and space, human concepts of fairness in the present context in particular have varied enormously. Human rights we take for granted today are rights which nobody would have recognized even in this country 400, 500 years ago. The right to marry, the right to a fair trial, freedom of religion, freedom of expression, they were all unknown in this country 500 years ago. And if you look at countries, other countries in the world, they're not known or not accepted. Some countries even freedom from torture isn't accepted, and it wasn't accepted in this country 500 or 600 years ago. But the fact that fairness is a concept which changes with time and place doesn't invalidate the search for what constitutes fairness. The fact that it may change from age to age or from one country to another doesn't undermine its fundamental importance to a morally just and just society politically and a successful society economically. Indeed, its potential for change and its consequent fragility makes it all the more important that we preserve and nurture it. When it comes to multicultural issues, they can involve two types of balancing when it comes to individuals. The first, which is more common, involve cases where the individual effectively represents a group within the state against the state. But it can also involve a case where an individual is against the group rather than against the state as a whole. In his excellent book, Raphael touches on a number of cases, most of which involve the individual representing the group and against the state. And two cases of particular interest to me were in the 1972 United States Supreme Court decision of Wisconsin and Yoder, where, as Raphael's already mentioned, the Supreme Court, by a majority of 6-1, decided that the Amish community was entitled to remove a child from education at the age of 14 or 15, even though it was contrary to the law, because it accorded with their faith. And on the other hand, you have the decision in 2014 of the Court of Human Rights in Strasbourg, upholding the Conseil d'État in France, Conseil constitutionnel in France, which held that wearing a burqa was outlawing wearing a burqa was perfectly permissible. It seems to me these two cases are very hard to reconcile, because I would have thought there was a much stronger argument for saying that the Amish view should not have been enforced when a child was involved. It was really visiting the parents' religious views on the child and depriving the child of education. And as Raphael says in his book, it's all very well saying that the child was an Amish child, but when he or she grew up, an Amish child would no doubt want to have the option, or might want to have the option, of joining society. And when it comes to a child's interests, it seems to me, as Raphael rightly says in his book, that the parents' desires play very much second fiddle to the child's desires, even if, as in the United States case, it's not a member or hasn't signed up to the Convention of the Right of the Child. And if, as was the case, the Amish community did not provide education for 14-year-olds and above, and they wanted their children, of course, to be educated in Amish schools, then the answer was simple. They should provide such education. And I do wonder if the same decision would have been reached now, or at least would have been reached by the Supreme Court in the United States 10 years ago. On the burqa case in France, I think that it is much more finely balanced. On the face of it, it's a surprising result that you should be allowed to ban the burqa. It's a purely personal decision whether a woman wears a burqa. There's nobody else involved. It's part of her appearance to the world, or hiding her appearance to the world. And to say she shouldn't be entitled to do that in public does seem to me, on the face of it, to be surprising. And when you examine the arguments, such as people finding it offensive, or people find, some more conservative-minded people find miniskirts offensive. Some more fearful people find people with skinheads and tattoos offensive. That's not a reason. And the idea that there are security implications because you don't know who's hiding behind the burqa seem pretty fanciful to me. I think the strongest argument's a more subtle one, and that's been touched on by Raphael too. And that is that one can see the argument that says that by our standards, and we are entitled to say this, even in a multicultural world, some aspects of Islam do involve women being treated in an unacceptable way, in terms of education and not being allowed out of the house and not being allowed careers and so on. And that we shouldn't tolerate. And it can be said, and I see the argument, and I can't pretend to have thought it through fully, that the burqa does somehow represent that, and that maybe on that basis one could justify it, but I'm doubtful about that. So I think those two cases are interesting and contrasting, And the other cases which he's mentioned, which Raphael has mentioned, which I found interesting, were two cases, one in the United States, one in Canada, both of which went the same way, each of which with one minority dissentient in the Supreme Court in each case, which involved a woman who married out of a community, as a result losing all her rights, property rights, because she'd married out, in circumstances where if it had been a man who'd married out, he wouldn't have suffered that loss at all. It seems to me that, and to be fair, those decisions were in the 1970s, that those decisions, to my mind, are indefensible, because although one can see the argument that says if you're a member of a group, you have to abide by the rules, it seems to me that where the rules are one rule for the man and another rule for the woman, that is just unacceptable in today's way of thinking. As I say, and as I said at the beginning, human rights and what is fair does change with time, and we live in very fast-moving world. And although in the eyes of the lifetime of the planet, 50 years isn't very long. 50 years ago, those decisions were made. The world, as far as I remember, was very different, and it may well be that it would be a different decision now. Thank you very much.
Thank you, Lord Neuberger, for these insightful comments about fairness and about the need for a balancing exercise between competing interests in order to define what fairness is. So we can't not turn to judges in order to define what fairness is, I think. Without further ado, I give the floor to our next speaker, Justice Elyakim Rubinstein.
Thank you very much. Good evening, everybody. Regards from Jerusalem. It's the only place on earth where speaking to the Almighty is a local call. So it is indeed a nice place to be in. First of all, kudos and Mazal Tov, good luck to Rafi on the book. Rafi is a really multi-functional scholar. I read articles and books by him on various subjects, and his curiosity is ever existing. And indeed, I fully agree with the general message of the book, which conforms also with my own inclinations of looking for balancing and compromises. And I'll focus mainly on our country, on Israel, because we are a good case study of complexities of all kinds. Let me say a word about myself. I'm a religious liberal Zionist Jew. That was my self-definition in my farewell remarks when I retired from the court 4 years ago. And I participated for many years in the peace process with our neighbors. And I also now, besides teaching, I chair the advisory council of our Ministry of Justice on questions of racism. It began with the attitude to Jews of Ethiopian origin, which are dark-skinned, and but we widened our work, and we also work on cases of relationship between Jews and Arabs, and within the Jewish community also with Haredi Jews, which ultra-Orthodox Jews, which dress differently and look differently, and how do you balance and how do you work with the general society when occurrences of discrimination come up. The book that we're talking about kind of balances between theory, between practice, and sends a very good message. The Israeli example, and I'm not an expert on France, and I read what Rafi writes on France, but I speak about our country because let me take my own family. I was born in 47, just before the state of Israel. My father lost his family, his parents, his sisters, his brother in the Holocaust. Both my parents went to the army in 1948. My mother also, a few years earlier, was shipped by the British authorities to fetch from Mauritius Jews who were exiled by the British in 1940 when they tried to reach the shores of Palestine, of Israel now, as refugees from Europe. And in 45, the British understood that there's no way to keep them or to send them back to Europe. So they agreed to accept them. And my mother was one of the medical delegation that brought them into the country in 1945. So my family has been involved in Jewish history, so to speak, in the former generation. And if you look at the situation in Israel, I'll mention just a couple of things. Rafi spoke of circumcision. Indeed, circumcision is something which is universally accepted, except in Israel, except for very few families. And the idea of using emla or cream to help in the procedure while not affecting its religious halachic religious law requirements is acceptable. And I think the solution that Rafi talks about is something which is to be accepted and respected. And it's within liberalism, and it doesn't infringe on what people would see as their religious practices. I base myself inter alia on Professor Abraham Steinberg, who's the authority on medicine and Jewish law in our country, and he accepts that idea. Rafi mentioned the Arab concept of the family honor, which is something rather terrible, and we referred to it in court cases, myself too. And I know that in the Arab society there are many who are against it, and it still continues. And there's a need for better leadership within the Arab community to fight against it, because really, I don't think any honest person, any fair person, and the word fairness, which was referred to so diligently by my honorable predecessor, is in place here, and this is something which should not be acceptable. On other matters of women, in Israel, we do have sometimes the practice that exists also in the US, that very religious, ultra-religious people want to sit separately in buses. And we had a case in which I wrote the decision called the Reagan case about 10 years ago, where the question was whether we can tolerate buses that do not allow the differentiation in seating between women and men. And interestingly enough, in the case, I was sitting with an Arab justice, Justice Jubran, and a secular Jewish justice, very secular, Justice Danziger, and we came to the same conclusion, that in principle, everybody can sit wherever they want on the bus. the rear door can be open so that if the women of the religious society want to sit in the back, that's their choice. But the driver has to enforce the ability by everybody to sit wherever they want. And I wrote basically the language of a sign to be put in all the buses where they open the rear door to women who want to come up, and with always ultra-religious, a sign which says, in this bus, everybody can sit wherever they want, and it's a criminal offense if somebody would interfere with anybody's choice. So we found a balance, and so far for 10 years it has existed, and there was no further litigation. And you should all, I'm sure most of you know, that in Israel, you can petition right to the Supreme Court in cases of administrative law and constitutional law, right to the Supreme Court without going through the echelon of courts. It's known as the High Court of Justice cases, or in the abbreviation of Bagatz. And this was one of them, and I'm just bringing it as an example. And Rafi also mentioned the compromise in the Wailing Wall, which I support wholeheartedly, which was so far frozen by the former government. Let me know, and I do support it because it did not infringe in any way on the, and I can't go into the details, on the religious requirements, but also gave leeway to conservative reform Jewish communities which are looking for their place in Israel. Let me refer, and this will be my last and main remark, to Arab-Jewish relations in Israel. I do not accept Rafi's definition that apartheid, no discrimination, yes. There's no apartheid, definitely, but there's also no official or government discrimination in the Declaration of Independence, but there are problems of discrimination. I mentioned myself chairing this advisory council of the Ministry of Justice, but not as a policy. In no way. In Israel, the Arab citizen is an equal citizen. It's enshrined in the Declaration of Independence, which enshrines equality. Unfortunately, and this is, I have to say publicly, that in the nation law, which was accepted as a basic law some years ago, they did not include this, the concept of equality. And the Supreme Court recently referred to it, saying, I cannot say the law is unconstitutional, but there should have been, and that's my personal view, and I speak about it rather often in Israel, we should introduce the equality into the law, which exists anyway. There's no court in Israel that would enforce any inequality, but the idea of putting it into the law to give the Arab citizen the feeling of partnership should be considered very seriously. And this is something which is of importance. I don't have the time to go into details, but I should say that I have been watching Israeli Jewish Arab relations, and they are on a scale of improvement for the many years now, not yet achieved the full solutions, but there's a new government now, for instance. Thank God there's an Arab party that is a partner to that government. There's also a minister from the Arab minority in the government. There is a huge budget, which tonight is being finalized to help the Arab society. Tonight is thank God, the vote on budget in Israel. And it is so, when you look, and I know the time is running, so I'll just say this. The complexity of the Israeli-Arab conflict and the fact that we have only achieved peace with part of our neighbors and the Palestinian issue is yet open to better solutions, is a reason why the Israeli internal Jewish-Arab relations have not been fully satisfied. But there are, and Rafi wrote about that, there are judges, there are Knesset members, there are professors in the universities, there are doctors, most senior doctors and nurses in the fight against COVID and in the Israeli medical system. There are Arabs in science, there are Arabs in high tech. Again, you can say the numbers are not yet as good as they should be, but they are all the time in a positive process. In fact, I'm running in a month or so, together with my former colleague, Justice Gibran, an Arab justice, a conference for judges in Israel on the Arab society to share more of the concerns, solutions, and achievements. So what I'm trying to say is that the good news are there, although we're not yet at the end of the road. Like many other subjects, it's dynamic. But so Rafi points at problems, but I think the term discrimination is not the right one. The term is complexity. So again, as the time ran out, I will congratulate Rafi on the book, and thank you all for your attention. Have a good evening.
Thank you very much, Justice Rubinstein, for these illuminating observations and very concrete, helpful illustrations of possible ways for a compromise. I will now turn to Professor Avrom Sherr for the final thoughts on Raphael's book.
Thank you for inviting me to talk on Professor Cohen-Almagor's new book, which he has described in some detail. I want to say, first of all, that I consider it to be an excellent book, and that it was one which really needed to be written. And as he's suggested, he's looked at how to handle the situation of different groups and cultures, and almost sets a dichotomy of either multiculturalism or integration. And this is rather what Cameron, Merkel, and even Sarkozy have expressed, as he mentions in the book. And all of those three were against multiculturalism, and Cameron for the reasons which were mentioned. So the author asks, can multiculturalism be achieved, and if so, how? Clearly, it is of immense practical importance, and you will see that it is of practical importance right up to today. The author has explained the structure of the book, and I would add only one or two comments. It is both a research study, but also something of a polemic. It is, I think, clear what he's aiming to do, and therefore it isn't, as it were, an open research study. There is this account of theory in the first 4 chapters, and then a theoretical construct is built, and he trials that construct, as he suggested already, where physical harm is caused and where non-physical harm is caused, and then there are 2 country studies. He asks where the dividing line is between allowing other cultures to thrive whilst ensuring that the rights of those inside and outside of the cultural group are not affected. He presents, and you've heard a little of these, a number of examples of issues with diverse cultural communities, some very interesting cases in both the US and Canada with Amish groups, Indigenous Americans, and others. And his approach is to find a way for those cultural practices and for those cultural groups to continue their cultural background as far as is sustainable within a different cultural tradition. He uses rules, as he mentioned, the veil of ignorance approach, so that you're placed in a position to consider from behind a veil without knowing which side of the argument you might be on. And this is a means of attempting a fair approach in making decisions. My comments are on these four elements: the chapters in theory, the theoretical construct, the case study, and a few questions. First of all, I have to introduce myself a little bit in terms of saying that with increasing age and a tendency to snooze just a little bit, looking at the theory of political science was a bit more difficult for me than I imagined it might be. But also I have to say that a large part of my time is supervising and examining PhDs in law. And so my approach may be different to Rawls and Mill and Kant and Raz, but it has been, as it always is, a good challenge to look at the approach of other disciplines. I was surprised in the beginning that law, which takes up quite a lot of the practical elements, isn't mentioned as part of the state. The state comprises an executive, a legislature, security organizations, and a bureaucracy. Law, yes, is there, judges, not. Mentioned a little bit later. And I suppose my question to the author is, since judges' judicial opinions, fairness, reasonableness are so important, maybe they should be mentioned a little bit earlier. But it's good to see all of these judges around today giving their views. So here is this aged law professor reading through bits of political science and beginning to wonder, do I actually know what all of these words mean? Yes, I use them in normal discussion, but I sort of began to think I needed almost a dictionary of the political science definitions for each of them. There is a lot there. This is a well-developed theory, and there's nothing wrong with that. I just answer that each of these, I think, is complex. And as you will see, I've tried to be rather more simplistic about it. So I looked at the Rawlsian view of ignorance from the other side, and I sort of got to something which I suspect some may recognize. Do not do unto others that which you would not have done unto yourself is another way of looking at it. Love your neighbor as yourself was, I thought, an easier way of understanding it. So when we look at this theoretical construct, my question is, did it need to be quite as complex? Because it is all of these items: rules, Kant, the democratic catch, reasonableness, cultural pluralism, etc. All of these are there in the construct, and it may be that it was necessary in political science. I wondered in legal science whether we would have made it quite so detailed. So each of these items is also described to an extent. I really liked, and I'm mentioning it here for that reason, giving up the desirable for the necessary as a description of compromise. But when I looked at reasonableness, just look at how complex it is: logical coherence, consistency, proportionality, suitability, necessity, sensitivity, etc. It is complex. But maybe this complexity is even more important, because at the beginning of this week, this is the Times this Monday, honor crimes are rising. Exactly what is talked about in the case studies, we see even more important than they have been, at least in England. They've risen by 81% in the last 5 years. This is an enormously important problem. And my first comment on the case studies then is how helpful they were in actually taking this theoretical construct into reality, and that helped me enormously. I wondered a little bit whether in just methodological terms there were particular reasons for selecting the ones that the author selected, but I really totally like the division between physical and non-physical harm, and I could see that very clearly. And rather like Lord Neuberger, the Amish discussion was well developed, and I entirely share with him the view that the Amish should probably not be allowed to take their children out of education. My own view was considering some of the problems which were developed by the author in relation to the safety of those children, that they might well be taken out of Amish education completely in order to maintain their safety. And I ask a question at the end here. So here's a new issue. How would you, author, apply your theoretical construct to something like different cultural food decisions, such as meat under ritual slaughter and halal and kosher, which are not permitted in Switzerland and Belgium? I'd like not to be able to have to deal with the animal kindness issues, but really just the cultural issues. But in other words, there are other questions. Some of the details are fascinating. I like the mention of the Aboriginal cultures, the recognition of Aboriginal cultures in ex-colonial jurisdictions. If anyone has been to Canada, Australia, New Zealand recently, you don't begin any lecture, any conference, any meeting without noting who are the original possessors of the land. But I take issue with the author on one item on page 198, which is a suggestion that women in Jewish Orthodoxy are treated in a way which is set out in texts which come from something like 1800 years ago. Women can be witnesses, they can be judges. They're not required to abide by discriminating beliefs and practices. And so I just suggest to the author that he's set up a sort of straw woman here, not one that we can recognize. This is a terrible picture, I'm sorry, but if you do have the Times of today, you will find that the issue that we're going to deal with immediately now is right across the pages. The Council of Europe, which, by the way, England and Wales, UK still belongs to, has suggested actually that the hijab is not such a bad thing. And they were doing very well until it was noticed by the French, and the French made them, or at least attempted to make them, take it all down and think again. That is really really sad. And that takes us to the case studies of the countries. And I would say the level of detail in these studies produces clear illustrations of some of the problems of multiculturalism, multi-ethnicity, multinationality. And these were the most interesting case study chapters for me. But I wondered why these were chosen as well, in particular. And that's partly why it sort of comes across a little bit more as a polemic than it might as a research study. And I can certainly understand the idea of these perfectionist models, but I think the two countries are very different. And actually the methods of assessment inside the chapters are very different. And I think the contexts are very different, but they were very useful opportunities to think in a wider context than just issues of what the author was saying. Now, the author started with the suggestion that multiculturalism might be bad for democracy. And he also says at one point, nothing democracy is nothing but a means to fulfill the needs and wishes of the electoral majority, notwithstanding how immoral they might be. And those of us who are anti-Brexit in this country know exactly what that might mean and how it might affect us. However, I'm just wondering about that, because whilst I was reading the book, the September elections occurred in Germany. And I started reading some of the support among the different parties. So the Greens, the Liberals and the left had a disproportionate support from one group, higher education and youth. The SDP and the centre-right and the populists had disproportionate support from those with lower education and from the over 70s. If one does the arithmetic, each of the main parties got just over 19%. And none of the confuser parties had serious support. But if they got together, then one or two main parties might actually be moved to make changes. So my question is there something in a way in which we can change democracy? So having shown my ignorance about political science, I'm now showing my ignorance about politics itself to the author. But could we actually change our systems of representation in such a way that issues of multiculturalism can be better settled at the ballot box and by changing that system? It's just a question. I really have no idea whether there is anything there that might be useful, but looking at this information about one set of elections suggested that we could do more in democracy. So overall, this is an important book on multiculturalism, highly acclaimed, much awaited, and the development of this construct is both relevant and highly useful. Now, we should be working on how it might be legislated or accepted. I've said that though liberalism feels a little bit like walking down the middle of the road, it is a much more ideal approach than integration or expulsion. And in terms of the examples, we're forced to consider, as Lord Neuberger has said as well, context. Context is everything. And it's very clear that time changes and views change with time. So interesting also to see that Cameron, who eschewed multiculturalism in England and Wales, it seems to be alive and well here in the UK. Most important, this book is a great achievement. Lots of interest. I hope that by asking a few questions, I have only shown that it's worth that interest. And I've enjoyed it very much. But more important, we should think about legislating and accepting it.
Thank you very much, Professor Sherr, for these interesting comments and the connections you make with democracy. And I'm sure that Raphael will want to jump in and respond to all those insightful observations briefly. Actually, there's a question which you might want to answer as well, Raphael, as you do, because it's connected. I will read it out, a question from the audience, pre-submitted. Thank you for your contribution to the understanding of the value of multiculturalism. The theory of just, reasonable multiculturalism is very comprehensive and sensible. Can you please elaborate on the concept of the democratic catch, so this idea of democracy? And maybe if I can abuse my position, I will just, it's not a question per se, but more of a comment about France. And I think that about democracy, there is probably a sort of political dynamic behind these growing restrictions on religious freedom and this obsession about the Islamic garb. And I think they represent a majority voice, a tactical political move. they don't represent unanimity. It's like when you travel abroad now, you're seen as being a Brexiteer because the UK has left the EU. Well, not everyone of us are. And in France, similarly, the Conseil constitutionnel upheld the law banning the burqa, but not the Conseil d'État actually thought the law would be in violation of the European Convention on Human Rights. So there's still a debate happening even behind these illiberal moves. But Raphael, the floor is yours for a response.
David, Neuberger, Elyakim, Rubinstein, Avrom, Sherr, first of all, I want to thank you from the bottom of my heart. I appreciate all the comments that you've been making and all the sharp criticisms. I embrace all of them and I appreciate all of them. They come from a very good place. And certainly we don't want to be all in one unified opinion. It's good that there is multi opinions on the floor, otherwise it'd be extremely boring. So it has given us something to ponder and something to learn from, and I certainly appreciate that. I should also say a personal note that I've been inspired for many, many years by the rulings and the writings of Lord Neuberger and Justice Rubinstein. Good for the people whose judges are Neuberger and Rubinstein. So thank you again. Let me start by saying something about discrimination of the Arabs in Israel. You see, for me, as someone who is true Rawlsian, whenever I come to a conflict, to a debate, to a dilemma, what I try is to be behind the veil of ignorance. So for the analysis, I'm forgetting who I am, which is very, very difficult to do because we are all product of our bringing, of our families, of our nationality, of our religion. But for the analysis, I'm a tabula rasa. I forget all these things. And I'm just looking at the reality and trying to analyze it as is. And in Israel, I'm disturbed by many things that I've seen throughout the years vis-a-vis the Israeli Arabs, Israeli Palestinians in Israel. I agree with Justice Rubinstein that it's not de jure. The law is equal to all. However, the application of the law is problematic at times, and there is a room, as he said, as he acknowledged, for improvement. And we've gone a long way, but there's a long way still to go for equality de facto in Israeli society. And as long as there is this schism between the minority, the 21%, and the majority, Israel will be aching, and democracy will be aching in Israel. So more can be done. Of course, I said quite clearly, there's no apartheid in Israel, and anyone who claims that Israel is an apartheid state either does not know what apartheid is, or does not know Israel. So I'm not speaking about apartheid, but I think there's more that we can do. And I brought forward certain ways, certain compromises that I think that Israel can allow, can permit itself as a sign of goodwill towards the inclusion and acceptance of the Arab minority in Israel. There's more that we can do. I thank Avrom for saying that I did not mention judges. It is my mistake. Of course, I have all the appreciation of judges, and I'm dealing throughout the book with many court judgments. And of course, it's just a slip of a pen, if you like. They should have been mentioned in that sentence. I agree. I also agree that it's a very complex theory. But what I had in mind are the case studies. And in order to address the case studies, I needed to formulate this complex theory. But Avrom, on the one hand, you criticize me that it's very, very complex. And on the other hand, you criticize me for not mentioning animal rights. Now just imagine how complex it's going to be if we need to introduce even more components to address the issue of animal rights. And you are now the second, within a week, there was someone else who wrote to me over the book and asked me why I did not address animal rights. Well, I need to leave something for the next book. I think that it was enough for me to address minority rights and women's rights and children's rights. I think it's enough for one book, something to ponder for the next time or for the next book. Now, about halacha, Jewish law, we have to differentiate between what the Jewish law says, halacha, what says, and then the application in Israel. Of course, in many respects, there is equality between men and women. To the same extent, there is equality between men and women in England. And feminists would argue that it's far from being perfect and there's still room for improvement. And I would agree. However, Jewish law doesn't change. Halacha doesn't change. And the quotations that I brought forward in the book are straight from halacha. And halacha, I'm sorry to say, is not very kind to women. Why did I choose France and Israel? I chose France and Israel because, as I said at the beginning, I was struggling with three questions: whether multiculturalism is bad for democracy, whether multiculturalism is bad for women, and whether multiculturalism promotes in one way or another radicalization and terrorism. Now, the conflict between human rights and security is very much felt in France and in Israel. In Israel, because of the Arab-Israeli conflict, and therefore Israeli Arabs, in the eyes of some people, are suspect. And it is a Jewish state, and there is a tension between Jewish state and liberal values of treating the others as you treat yourself. And because security is the most important value, if you like, in Israeli society, then it was an obvious case to study, to see the impact of security on multiculturalism in Israel. And I argue there is a substantial impact. France, because some of the critique of the Muslim garb has to do with the fact, or at least the notion that was given by some who claim that the burqa is a tool for terrorists. So some terrorists hide behind the burqa. And women should reveal themselves in public and not hide themselves in public, because then it's a hazard, if you like, for securing public peace and public order. And it plays to the hands of terrorists. So this is why France came into the fore. I'm not comparing between the two societies. They are very, very different. But at the end of the day, I'm saying that both societies have to improve on liberalism in both societies, on the rights of women and the rights of minorities in both societies, and stop hiding behind security as a pretense for discrimination against minorities. A question I've been asked about democratic edge. Well, democratic edge is a theory that I developed already in my doctorate and I continue to use in my writings. The idea behind democratic edge is the following. Many scholars have claimed that in all forms of governance, with the exception of democracy, the very principles of the form of governance might undermine that form of governance, which is quite clear when you think about authoritarian regimes, dictatorships, or theocracy. One can do that much with sitting on bayonets. At the end of the day, the bleeding as a result of sitting on bayonets is going to backfire. And people are going to rebel against the coercive regime that they have to endure. But, so scholars claim, democracy is different. It is different because it is not based on coercion. It's not authoritative. It's based on the will of the people. I've been arguing that actually, when you think about this, democracy is not different from the other forms of regime by the fact that the very principles that underlie democracy might bring about its destruction. Think about what are the principles that underlie liberal democracy. The first is liberty, freedom. But if you allow freedom without any restriction, without any boundaries, then the results might become an anarchy. The second principle is tolerance. But again, to what extent we should tolerate the intolerant? We have to put some boundaries. Otherwise, again, it might backfire. A third principle is pluralism. But we can't allow any opinion to be represented in the Knesset or in the parliament, because then we are going to have a very, very large Knesset. So what I'm showing in this theory of democratic age, that the very principle of democracy might undermine democracy if we don't put them in check. And of course, it's very relevant here when we see that we have practices that are inherently illiberal. And then we have to question ourselves to what extent we need to interfere in order to put them in accordance to our values, the liberal values within democracy. So that's why the democratic age is very much relevant to my discussion about multiculturalism. Thank you.
Thank you, Raphael. We move on maybe to two questions, less about democracy and more about your theory of multiculturalism from the audience. One asks you to elaborate on the concept of culture for the purpose of defining multiculturalism. And the other one asks you to comment on the Canadian approach to multiculturalism as to what might be working or not working in that approach. Raphael.
Well, I use the term culture in the broad sense, and of course it also includes religion in it. It's a group that has certain rights, certain tradition, certain history, and they think that this history is a way for themselves to define themselves. And they orchestrate the community around the principles of this community, be it is religious-based or they can be cultural-based. I think that, I said that in Israel, I think the most important value is security. It seems to me from my studies of Canada, that the most important value in Canada is multiculturalism. And Canadians go out of the way, unlike the United States, the neighbor, they go out of the way to, I'm not saying to completely accommodate all the cultures in Canada, but there's certainly people who come, and Canada, United States, Britain, Israel, Australia, New Zealand, they're all immigration countries. They're all countries that benefit a great deal from immigration. In Canada, I think that people, when they come from all walks of life, from all parts of the world, they feel embraced, they feel at home. The people don't care where they come from. It seems that it's something within it's ingrained within the psyche of the community, of the society. And this is why discriminatory practices of the First Nations, the native Canadians, can have this latitude, can have this tolerance that they have now. Although, of course, the people who pay the price often are women, unfortunately, in those tribes. So this is the situation in Canada, and Canada, because it's cognizant of the value of culture far more than, I think, other democracy, we can see the discussions about this all the time on the agenda. It's part of the Canadian political life. And this is, for people who are interested in multiculturalism, is fascinating.
Thank you. There's one more question, and if our speakers would like to bounce back on anything, maybe they could raise their hand or mention in the chat while Raphael answers this question, which I'm about to read from the audience. So the question is as follows. Thank you for a timely and most important book. I wonder how important the concept of consent is in your theory of just reasonable multiculturalism?
I would be happy to answer this question, but I saw that Rubinstein wanted to say something, so I defer to him.
Well, first of all, I would like again to really express my admiration to your effort, to the book, to the intellectual investment. But I also want to say on Israel that indeed we are in a process. It's always dynamic, and I would like to underline the role of the Supreme Court in helping to achieve more equality or to implement equality. And this, by the way, applies to all human rights areas, including gender. We don't have the time to go into examples, but gender issues, including religious issues, and including Israeli internal Arab-Jewish relations. And the fact that you can go straight to the Supreme Court, like in a way the Athenian public square or the biblical city gate, and talk to power in this way, straight to the highest court of the country, is, in my humble opinion, and I'm not fully objective, a real gift to the public in a way. And I'd like to mention that this week we lost one of the great justices, who Raphael knew well, of the court, who served as deputy president of the court, Justice Elyakim, who contributed to all these areas in his own day as a justice. Thank you very much.
Raphael, would you like to have the final words, maybe answer the question or just conclude the event?
And I'll have to apologize because I have another commitment, so I'll leave in a couple of minutes, and again, congratulate you. Thank you very much.
Thank you, Eli, and I want to thank you also for mentioning Elyakim, one of the cleverest, nicest justices of the Supreme Court, a person who was very, very modest, unlike what he offered the State of Israel, because his contribution was immense. Eliyahu was a mensch, and we lost him. And I think Israel lost one of its greatest judges this past week. So thank you for mentioning Elyakim. With regard to the question about consent, of course, consent is extremely important here. It's important when we deal with women who accept upon themselves certain rights. So I did research among the Bedouins in Israel, and the Bedouins at that time accepted the right of female circumcision. And I wonder why they accepted this right, why there was no rebellion against this. Of course, I could not speak to them because I'm too foreign for them. I'm Jewish, I'm a man, and unacceptable. But I did speak with social workers who worked all the time with women in these communities. And my understanding of this is that's something that I call internalized coercion. So sometimes you assume upon yourself certain norms of the community, but you don't feel that you are coerced to do that. It becomes part of you. As for many Jews, they accept male circumcision whether they like it or not. Simply because you're Jewish, you have to do it without too much paying attention to this. Of course, the question of consent is also tangible with regard to male circumcision, because at least in Judaism, we do this in the 80 days, and you can't ask a small baby to give consent. There are some people who said we should postpone male circumcision to the age of 16 or 18, and then people may give consent. Balancing the pros and cons of this proposal, I was against this because of the pain that is involved when you are 8 days old and when you are 18. I think it will be far more complex as a procedure, as a surgery, to do it at the age of 18 than to do it in the age of 8 days. And for this, I consulted physicians who do this, and Moalim, those who are expert on this, and they all told me it would be a mistake to postpone this. So without the consent, the parents will have to make the consent for the child. So the issue of consent is extremely important in my theory, and it's very relevant to women's rights, and of course, it is very relevant to children's rights.
Thank you very much, Raphael. Thank you, everyone. Unfortunately, I think it's time to draw the event to a close, but we haven't exhausted, far from it, all the questions that you touch upon in the book, Raphael. It's a very, very rich book. And I hope that from the discussions that everyone has noticed that it has a theoretical underpinning as well as a contextual analysis backed up by empirical studies and interviews, as you have just mentioned. So I would recommend to everyone the reading of the book. Thank you again, Raphael. Thank you to our speakers, and thank you to the audience for making this event a success.
Thank you.
And thank you, Myriam.
Thank you. Thank you very much.
Yes, thank you very much indeed. Thank you.